Hey, everybody, and welcome to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel, and it's Thursday night once again. We're here live on the YouTube channel going over your questions related to debt collection, bankruptcy, and all those other horrible things out there. So we do this each and every Thursday night. I'm trying something a little bit different tonight. Try and see if I can actually stream this from my iPad. It might make me a little more mobile, maybe be able to do things a little bit easier outside of the office. So if you can't hear, if there's anything like that, please let me know, because I kind of have a different audio visual setup this week. Put that in the chat and let me know if there is an issue with that. But if you're new to the channel, again, my name is John Skiba. I'm an attorney here in the state of Arizona. I work for the law firm of Jackson White. I do bankruptcy, and I help defend people who are getting sued by debt collectors in the local courts here. So the whole purpose of my YouTube channel is to provide some tips and resources and strategies as far as ways that you can be benefited if you're dealing with some of these serious debt problems. Because the main thing I've seen in 20 years of doing this is that my clients and people who don't hire me, they end up in trouble because they don't take specific action on their debt issues, and they just become worse and worse and worse. So that's what we do here. While I am a licensed attorney, you've got to remember this is some dude talking on YouTube, and so don't take it as legal advice. If you need legal advice and you're in the state of Arizona, my information is below this. I do free consultations. If you're not in Arizona, I recommend you contact an attorney in your particular state. So how we do this is you go ahead and put the information in the if you're on YouTube watching this, you can put a question in the chat section there. I'll put it up here on the screen, and I'll go over there and give you some tips and maybe some different resources that you can take a look at. All right, let's jump into, there's already a lot of questions, so let's jump into them. A lot of good ones already. Dan Demand says, big fan of your content. Thank you, Dan. Question, arbitration granted 7 months ago, sent an email for them to initiate, never heard back. Plaintiff now ordered. I'm definitely feeling that there's a second part to this, Dan. Go ahead and put that up, Dan, when you get a second, and I'll finish it. But here's what my guess is, that the plaintiff, the issue that we run into, so to give you some backdrop of this, when debt collection lawsuits are filed, you have the option, if there's an arbitration clause in the terms and conditions of the credit card, to request that the matter be sent to private arbitration. So you can file a motion with the court to compel private arbitration, which is what Dan did here. Said he filed this motion to compel. It was granted 7 months ago. He sent an email to the creditor for them to initiate it. And the second half of this story is that the plaintiff now ordered to show cause pending dismissal in upcoming hearing. Plaintiff has now filed a motion to compel me to file arbitration or in lieu of motion for summary judgment. Okay, so the battle continues. The battle begins. It's not surprising what they're trying to do here. So the order to show cause, that's a good thing, because that tells you an order to show cause hearing is the judge's way of saying, come in here and tell me why I shouldn't enter an order of contempt against you, plaintiff, for failing to initiate the arbitration. And so them filing their motion to compel you to file arbitration is their way of saying, no, not us, they should do it. I have kind of changed my approach to this over the years, over the months, I should say, because it's fairly recent, that if you need to initiate arbitration, go ahead and do it. You can go to AAA, American Arbitration Association, or JAMS, initiate the arbitration, then go to the court, file a notice, say, look, I did it. Let's move this thing forward. And I think it'll still get you where you need to be. So that's what I would do. But it's a good sign that the court has filed an order to show cause hearing against the plaintiff, because they are clearly saying, look, we think that the court is saying we think the plaintiff should have initiated this now. They haven't done it. And so you could go to that hearing and ask to be dismissed, that the lawsuit be dismissed, or alternatively, if they are going to require you to or whatever, just go and initiate it yourself. So, all right, Al, thank you for being here. It says, I've seen conversations where people have second thoughts, change their mind, and can withdraw from their bankruptcy filing from the bankruptcy after filing. Is it possible? What happens? Depends on the chapter of bankruptcy you're in. If you file a Chapter 7 bankruptcy, there's no backing out. Once you're in, you're in. And that can be pretty harsh, in a lot of situations, because sometimes there are assets or transactions that I've had that happen before where clients don't tell me about them. The court finds out about them after the fact, and then they're in a situation where they're stuck. They're in that Chapter 7. They're either going to lose the asset, or they can convert to a Chapter 13, which sometimes we'll do. But a Chapter 13, so Chapter 7 is about 4 to 5 months. Chapter 13 is 3 to 5 years. Much longer process, more expensive, and you have to pay some of your creditors back. Now, Chapter 13 is a whole different story. If you file a Chapter 13, you have the absolute right to dismiss the case at any time. You can get into a 13, you can be going along. I've had clients in 13s for years and then say, you know what, change the circumstance, we're not going to do this, and they dismiss. Now, it's important to note, you can't file a Chapter 7, convert to a 13, and then dismiss. They're aware of that trick. So you can't do that. The rule says, Chapter 13, you have an absolute right to dismiss unless you previously converted from a prior chapter, like a Chapter 7. Then you're not going to be able to do that. So thank you, Al, for the support. All right, Alex, thank you. As always, number one fan here, Alex, appreciate it. Do personal loans generally have an arbitration clause? It's already getting hot down here in Yuma. You know what? It's so funny. Here in Arizona, we've had, at least in the Phoenix area, we've had what feels like a real winter to us. I know that everybody else is buried in snow, but it's been usually around Christmas, New Year's, it's a little bit cold here. It's been fairly cold. I mean, we're in the low 30s in the morning, which is super cold for Arizona. And even the mountains have snow around the Phoenix area, which is kind of weird. But I saw it's supposed to be 85 on Monday. So I guess winter is officially over. So do personal loans generally have an arbitration clause? I can tell you that, so it depends on, I guess, what we mean by personal loan. Personal loans, I did what's called compulsory arbitration hearing just earlier this week. It was on a business loan, like one of these web bank type loans, Loan Me, LLC loans, these kind of things. And it absolutely had an arbitration clause. It was a personal loan. It was a business loan. And it was actually a humdinger of an arbitration clause. And so I was reading through it because it said that the creditor, they would pay all expenses related to the arbitration, including your fees. So your filing fees, everything. It covered the consumer's fees in totality. So you always have to just go and check that fine print. That's the fine print that we all gloss over, including attorneys. I always think that when I buy a new car or sign up for some contract that I look and, I'm just signing. I even tell the guys, look, I hold people accountable for these contracts all day long at work, and I just blindly sign them when I get out there. But go look at the arbitration clause, dig into the fine print, and see exactly what it has. All right, let's see here. Let's go back to some of these that were right at the beginning. Smooth landing. First one here today said, received a court dismissal hearing scheduled for next month after no movement of plaintiff for a year after my answer. What should I expect? Is this common? So it's a positive thing from the point of a defendant, because in a case with most states, like for Arizona, for example, in the justice court system, if you file a complaint, if a creditor does or a plaintiff does, the court says you have 10 months to get this thing done with. You can't just let it sit out there and linger and then eventually come in and try to get a judgment. So like in Arizona, if it sits there for 10 months and a judgment hasn't been entered or a trial date's not set, the court will just dismiss it. And they'll dismiss it usually without prejudice, meaning it could be refiled. But in a situation like this, if there is a hearing set, this is the court's way of saying to the plaintiff, what are you doing? This is just sitting here, nothing's happening. And what I would do, I would ask the court to dismiss the case with prejudice for failure to prosecute. That, they can't just file this lawsuit, park it, and then not do anything with it. So that's what I would do. I would ask the court to dismiss it. They may dismiss it without prejudice, or alternatively, they may give them some additional time and set a trial date. Just kind of depends on what your court is, tending to do. So, all right. Daniel had a good question and a timely question. He says, student loans in bankruptcy, tips for an adversary proceeding. So traditionally, student loans have been non-dischargeable in bankruptcy, meaning they didn't go away. They amended the bankruptcy code back in 2005. They made it more difficult. Really, any loan taken out for an educational purpose was deemed non-dischargeable, meaning it couldn't go away. And the bankruptcy code remains the same. However, there's been a tweak in the way that things are being done that's going to make it much easier for people to discharge student loans. And I can tell you, in my bankruptcy practice here in Arizona, we are evaluating all of our cases to see if the debts can be discharged in bankruptcy, or the student loans can be discharged in a bankruptcy, Chapter 7 or Chapter 13. So to understand kind of what this change was, you kind of have to understand how student loans are eliminated in bankruptcy. So most debts, you file your bankruptcy case, the debt is you file the paperwork, and you get a discharge order at the end, and everything's gone. But with special debts like student loans, in order to discharge them through the bankruptcy process, you had to file something called an adversarial proceeding. It was kind of like a little mini lawsuit within your bankruptcy, and you actually had to sue the student loan lender. So if you have a federal student loan, it would be John Skiba versus the United States of America, Department of Education kind of thing. So you would bring this little lawsuit within the bankruptcy court, and you had to really articulate why it is that your student loan debt should go away. And there's something called the Brunner test. And essentially, previously, the standard has been so high that the courts have had to apply. And I should say this, the standard still is high, that most student loans still, even if you went through that process, they were often not discharged. However, here's what the government is doing right now. So when you sue the government, whether it's Department of Education, United States of America, whatever it is, the attorneys that represent the country or the government are the U.S. attorneys, and that's part of the Department of Justice. And the Department of Justice has given some instructions to their attorneys, to these U.S. attorneys, as far as essentially how vigorous they should defend these types of lawsuits. In the past, they fought us on it. That's why often you couldn't get it unless there was a real severe disability or inability to pay. Usually they survived the bankruptcy discharge. So here's the process. And this is timely because I just attended a continuing education class on this last week about some of these updates. The process is still, you file bankruptcy, whether it's Chapter 7 or Chapter 13. You have to file an adversary proceeding in the bankruptcy, which is this little lawsuit that says, hey, we think that these debts should go away because it's a hardship on me, or when I'm filing it for my client, it's a hardship for my client to be able to pay these particular debts. And when you do that and you serve the Department of Education, the U.S. attorneys that are responsible for representing the government in those cases, they will then send you something called, I'm looking at my notes over here, I believe it's called a litigation packet, okay? And there is a 3-prong evaluation that they have you fill out. And let me walk through my notes, okay? First prong is income and expenses. They want to know, it says, is my client's income subtract, minus expenses less than the standard repayment plan is calculated above? So you have to go through what the normal repayment plan payment would be on your student loans, just a typical standard 10-year payment plan. They want to know if we take your income and subtract out your expenses, is the amount that's left over less than what it would take to make a regular monthly payment on your student loans? If that is, then you go down into these 3 prongs. The first one, they look at your future inability to repay student loans. And they have a bunch of check the box things. One of those is, are you over the age of 65? The next one is the loans that are to be discharged in the bankruptcy, if they've been in repayment already for at least 10 years. And the third one is if you did not complete the education for which you received the loan. So if you didn't finish school. The third one is if you have a permanent disability or a chronic injury, which renders you unable to work or limits your ability to work. The next one is if you've been unemployed for 5 of the last 10 years. And then there's some additional reasons that we can check. If you're currently unemployed, if you're unemployed and if you're employed but cannot find work in the field that you're educated for, if you're currently employed, but your income is not likely to increase to result in any kind of substantial increase in the payments on the loan, or if there's any other reason. Then the next prong they look at is your prior efforts to repay the loan. And then they have us look if you are currently making payments on your student loans, if you've made them in the past, if you've applied for a deferment or like a grace period, if you applied for what they call an IDR plan, an income-driven plan, where you applied to the federal government to have your student loans reduced based upon your income, if you've applied for a federal consolidation loan, if you've reached out to a servicer or a collector to meaningfully discuss your different options. And that's really it. So those are the things that they look at. And if you check off all those prongs, they have said that they anticipate that 80% of they will stipulate, I should say, they'll stipulate that your student loans will become dischargeable in bankruptcy. They're predicting in 80% of the cases that get submitted. So that's huge. I mean, I see student loans, hundreds of thousands of dollars almost every day that people are dealing with. So yeah, if you can check those boxes, then you're in a situation where you may be able to do that. So if you're in the state of Arizona, feel free to reach out to me. And this is something, whether it's 7 or 13, we can evaluate, determine if it's something that you can, you can get rid of. So, all right, Mark has some questions. Mesa Justice Court, I know it well. I motioned for compelled to arbitration versus mid-first attorneys. Their response was to file a motion for a 30-day stay for you, the defendant, to initiate arbitration. The court granted that. I did initiate it and informed them that informed the court that AAA had sent a letter to mid-first attorneys requesting their fees. They have until 3/14 to respond. Clock is ticking, mid-first, because it's almost there. And they have just filed a motion for summary judgment in the Mesa Justice Court. Judge Fred Arnett, I have a written response, but was hoping you would see this and give me an idea. Okay, so what you have to look at is if the court ordered a stay for 30 days and you filed the initiation with the private arbitration within that period, and you provided notice to the court should throw out their motion for summary judgment. And I would I would not just let it sit there, but I would file a motion saying, hey, the court stayed this, and they went ahead and did it anyway. They violated the court's order. The court should throw that out. I don't see that being an issue. If you can, I would attach a copy of the order staying the litigation, attach a copy of the notice that you provided to the court, but the court should throw that out. Their mid-first is being a little bit wise guys there. So I would just let the court know, and they should toss their motion for summary judgment. So, all right, Monterey says one of my Bank of America cases, not small claims, had a jury request in February of 2022. Clerk told me to set an agreed to trial date. I got through to Bank of America's attorney a year ago. He never got back to me as promised. The case is pending in limbo for over a year in Travis County, Texas District Court. Does Javich block like leaving cases in limbo? I'm assuming that's the judge. I don't know. I don't know what Javich likes to do. I know courts don't. And that's what I'm saying. Like in Arizona, there's actually rules that push the case along. Here's what I would do in situations like that. I would file a motion to dismiss for failure to prosecute. If they're not going to push this along, and I would outline exactly what you've done. You reached out to them. They're not getting back to you. If the case has had no action for a year, I would definitely file a motion to dismiss for lack of prosecution. And they may not dismiss it, but if anything, they'll get the case moving forward. But the court may agree with you that they've really sat on their rights, and so they're good. You could be good to go there. So, all right. So Triple Crown has to say, I know I need to live in the state where I file for Chapter 7, but can I move out of that state before my case is dismissed? And then assuming you're meaning discharged, which is ended, and yes, you don't have to stay. Once the jurisdiction of the court is based upon the time when you filed your case. So you can, and that happens routinely. I have clients who file and they move to a different state. And one thing that's kind of nice now is the meeting of creditors, the 341 meeting, which is in every bankruptcy case. It's done virtually. And the Department of Justice said that's going to happen. That's permanent. So they're done over the phone, or sometimes Zoom. Yeah, I did a video a while ago where I talked about. I actually went to the bankruptcy court for the first time in 3 years. We used to be down there 4 to 5 days a week doing the meeting of creditors. So yes, you can do that. Same with the Chapter 13. We have cases with the Chapter 13 where it's it's 5 years long, so they'll move out and we can still process it there. So, all right, Marco says, good news. I initiated arbitration with AAA as ordered by the court. Just had my hearing yesterday, and LVMV filed to dismiss the case without prejudice, and the judge accepted it. Nice job, Marco. You did it. And okay, you have a good follow-up here. Fortunately, the case is now past the statute of limitations in California, so they can't come after me again. Yes, you're right. So I always like to have cases dismissed with prejudice. That means that the case cannot be refiled at a later date. The court dismissed it without prejudice, but because they're outside the statute, it's done. It's over. If they do that, it's an FDCPA violation. You'd be able to sue them. So, all right, let's see here. 03, love your channel. Thank you, 03. In Arizona, does the trustee determine if Chapter 7 is discharged, or is it the judge's decision? It's always the judge. So the way that the bankruptcy court world is set up, you have bankruptcy judge who's up here who rules the bankruptcy universe. They have, you and your attorney, and then the bankruptcy trustee. Essentially, they don't represent creditors, but they represent, in general, kind of the government's interest in this. They review the case. They look to see if there's assets that can be liquidated. If they don't believe you're entitled to a discharge, they can object to it. But at the end of the day, it's the judge who makes that final decision. So, all right, let's see this one. How to proceed with a law firm that says they don't own the debt, but they work on behalf of the credit card company. I already sent validation letters. That may take me to court in the next few months. So this is a good question because I get this quite a bit. It is important to understand that usually the law firm that files the lawsuit on behalf of debt buyers, usually they don't have an ownership interest in the debt itself. They're just hired guns. They're like all the rest of us attorneys. That's just their client. So like in Arizona, there's like 2 or 3 big collection firms. They don't own the debts that they're seeking payment on. They're getting paid, or however they're getting paid, whether it's hourly, like a lot of attorneys, contingency, flat fee, whatever it is. They don't own that. And so if they haven't filed a lawsuit, or if they're not sending you correspondence, then you reach out to the original creditor to request validation. If they're sending you letters, though, by law, by rules, I should say, if you know they have an attorney, you're going to go through their attorney, and they should still validate the debt. Say, all right, let's see here. I think that is about it. Marco, thank you. I'm glad that you got a good result there, got that behind you, and can now move forward. So I think we'll wrap that up. Appreciate everybody checking in today. Hopefully that trying to do this from an iPad didn't cost too much and people can still hear it. I don't have my big fancy microphone, but I will. I'll get hooked up to that as well. Again, if check out the link at the top. I have the Consumer Warrior University set up. Then you can get access to all of my courses, templates, tutorials, everything. And that's all there. We have a bigger group each week, and it's awesome because people can share tips and strategies and things that have worked for them. So appreciate everybody checking in tonight, and we will catch you next